If you're watching this and you're a business owner that has a business partner, you typically have an operating agreement. In that operating agreement is a section that's titled buy sell. This section of your operating agreement talks about if something were to happen to you via death, disability, retirement, or a business divorce, how you would typically fund that buyout from a business partner, the valuation methodology, etc. Oftentimes, what counsel recommends is that you consider purchasing life insurance to help buy out a deceased business partner from this buyout if one of your partners were to pass away prematurely. Oftentimes, this is something that is reviewed once at the inception of the business, and oftentimes isn't reviewed at any point post you putting the business in place. If this is you and you're watching this, you're wondering, what maybe is this person talking about and why is this relevant for me? Well, recently the Supreme Court had a case that was referred to as the Connelly case, which addresses this issue. And ultimately, what the courts concluded is, if you have life insurance and it's owned by the business, and the beneficiary of that life insurance is the business to help the surviving business partner buy out the estate of the deceased business partner, ultimately the life insurance policy is added to the value of the actual business in calculating that value for federal and state estate taxes. So this is a huge ruling from the Supreme Court on this matter, because for many, many years, most CPAs and tax attorneys have viewed the liability by the surviving partner to buy the shares from the deceased partner as an offsetting liability from an accounting perspective. Therefore, the life insurance benefit did not increase the overall valuation of the business. However, this ruling by the Supreme Court ruled that no, in fact, if you have life insurance to fund a buy-sell agreement and the policy is owned by the business, that total amount of life insurance gets added to the actual value of the business. So let me give you an example of what I mean by this. Let's suppose that there's a business that's worth $10 million, and I have a business partner that's 50-50 partners in that business. So I own $5 million of value of the stock of that business, and my partner owns the other $5 million. And for our buy-sell purposes, I have $5 million of life insurance on him, and he has $5 million of life insurance on me, and the business owns the policies. Why is this so important? Well, for federal estate tax purposes, you have a certain amount of your estate that is exempt from taxes, both federally and if you live in one of the 18 states where there is also state tax on your taxable estate, then this could have huge ramifications for how much tax liability you or your family may owe because of this simple ownership structure of life insurance policies to fund a buy-sell agreement. So this ruling by the Supreme Court has really affected a lot of people, and you might not even know that you're affected by this. So if you're watching this video, this could be a very simple solution that can be in place just by taking a few hours out of your day to review your buy-sell portion of your operating agreement with your attorney, and then reach out to your financial planner, insurance agent, if you have life insurance in place, to consult with him or her on how you can use this recent ruling by the Supreme Court to review and or modify any existing policies that are in place. If you're interested in reaching out to our firm as a resource, we'd be happy to consult with you on this matter. Please reach out to us on our website, instrumentalwealth.com, message us through social media. We'd love to have a deeper conversation with you around this if this is relevant for your situation. Thanks, everyone. Have a great day.